Hi, my name is Yogya Bhatia and I am a legal intern at LEXIS and Company. Today I'll be talking about criminal intimidation. The Indian Penal Code 1860 is the substantive law governing the criminal activities in India. Chapter 22 of the code, consisting of Section 503, Section 510, provides for offences which fall in the nature of criminal intimidation, intentional insult, and annoyance. The law has an objective of punishing offenders for all kinds of criminal offences, but in contemporary times, the law does not entirely mirror the changes that have taken place in society. Although the provisions are relevant and binding, they fail to address the technological advances in today's world. The law is archaic but provides a base for new developments. Criminal intimidation. The offence of criminal intimidation is defined under Section 503 of the Indian Penal Code 1860. The provision states that anyone who threatens any other person on the following grounds is liable for criminal intimidation: threatens injury to his person, threatens injury to his reputation, threatens injury to his property, threatens injury to the person or reputation of anyone in whom the person is interested. Further, the intention should be to cause alarm to the person or to make them perform any act which they are not legally bound to do, or to omit any act which they are legally entitled to perform. If they are forced to do all of these acts as a means to avoid execution of such threat, this amounts to criminal intimidation. The explanation of this section says that a threat to injure the reputation of a deceased person in whom the person threatened is interested is also covered under this section. For example, A, for the purpose of inducing B to refrain from filing a complaint against him, threatens to kill B's wife. A is liable to be punished for the offence of criminal intimidation. The Supreme Court, in the case of Vikram Johar vs. State of Uttar Pradesh, has observed that the mere act of abusing a person in a filthy language does not satisfy the essential ingredient of the offence of criminal intimidation. The complaint was the accused came with a revolver to the complainant's house and abused him in a filthy language. They also attempted to assault him, but when the neighbors arrived, they fled from the spot. The bench held that the above allegations prima facie do not constitute the offence of criminal intimidation. The Tripura High Court, in the recent judgment of Sri Padma Mohan Jamatia vs. Srimati Jharna Das Baidya, has observed that the mere use of abusive words, filthy language, and body posture during the speech of political leader is not induced within the ambit of the provisions of the criminal intimidation under the IPC. In the case of Mani Taneja vs. State of Karnataka, the Apex Court held that the post comments about ill treatment by the police personnel on Facebook page may not amount to criminal intimidation. In this case, the appellant was involved in a road accident wherein she clashed with an auto rickshaw. The passenger of the auto sustained injuries and was subsequently admitted in a hospital. The appellant duty paid all the expenses of the injured and no FIR was lodged. However, she called to the police station and was allegedly threatened by the police officers. Aggrieved with the way that she was treated, she posted comments on a Facebook page of Bangalore Traffic Police, accusing the police officer of harsh behavior and the harassment she had. The police inspector filed a case against the appellant for this act and an FIR was registered under Section 5353 and 506 of the IPC. The bench held that there was no intention on the appellant's part to cause alarm under Section 503 of IPC. In Sri Vasant Women Pradhan vs. Dhatare Vitali Salvi, it was held that the intention is the soul of criminal intimidation. It needs to be gathered by the surrounding circumstances. The extent of nature of the threat. It is not necessary that the threat is direct in nature. In A.K. Gopalan vs. the State of Madras Union of India, the court held that if a speaker at a public meeting threatened police officers stationed at Malabar with an injury to their personal property or reputation, then he was liable for committing the offence of criminal intimidation. The nature of the injury threatened. In the case of Nand Kishore vs. Emperor, a butcher who sold beef was threatened that if he indulged in the acts of buying or selling beef, then he would be sent to jail. Further, his living in the municipality was also threatened. The court held that this amounted to criminal intimidation. In the case of Anuradha Krishnagar vs. State of Maharashtra, the accused allegedly threatened the female teacher by shouting that the teacher should be caught by the hair, kicked on their waist, and pulled out of the hall. The Bombay High Court ruled that these remarks constituted the offence of criminal intimidation. The Orissa Court in Amulya Kumar Behra vs. Naban Behra alias examined the meaning of the term alarm. The court held that the mere expression of any word without any intention to cause alarm was not sufficient to be brought under the ambit of Section 506. The court also observed that his provision is relatively new and originally termed like terror or distress has been proposed instead of alarm. In Amitabh Adhar versus NCT of Delhi, it was held that a mere threat does not amount to criminal intimidation. There must be an intention to cause alarm to the person threatened. Thank you.